All right. Good morning, everybody. And it is good to be back. As you know, last week I was out of town and I still was able to make a few videos, but some people noticed the background was different in one video, and the other video I was using a virtual background. So now we're back home, back in our office in Michigan. Made sure that we came back for the ice storm that we got. And this morning was no jokes of how to actually get to the office. So it was a little busy and a little slippery, but thank God we made it healthy, well, and getting ready for this hearing now. So glad that you're all joined me. Here we go. We got from Mathis Greece. Greetings from Germany. Looking forward to listening to lawyers argue about money. Isn't that something fun? Listening to lawyers argue about money, who's going to pay for what costs. But who knows? There'll probably be some other things to discuss as well. But yeah, that's what lawyers do. Sometimes we just argue about money. And good morning to Nania King. And if I'm mispronouncing your name, I apologize, but I'm doing my best. So good morning, Brother Counsel. Good morning to you. Good morning, blurry lights, to our wonderful moderator of today and for probably the going forward and last live. So appreciate all of your work, blurry lights, and appreciate your support of the channel. We got Mary. Good morning to you, Mary. Hi. Please cover the Jennifer Crumbly hearing from the other day. Okay, Jennifer Crumbly, before Karen Reed's getting started today, because I am watching it. Don't worry. As soon as it goes live, we will post it right here also. Okay, what's going on with Jennifer Crumbly is really, really interesting. Okay, I don't know why more channels are not picking this up. I mean, I probably should do something because it's such an important issue. And like I said, anytime I cover the Jennifer Crumbly case, this is the first time in history that you're having parents charged with a crime that they allowed their son or whatever. They're charged with a crime basically because their son went on a school shooting. So are we going to be starting to hold parents culpable, criminally culpable, for the criminal actions of their children? So I always talk about it. It's such an important issue, something that we really have to get right. And what happened in that case is really strange. And it's really unfortunate, and it should have never happened. And it's improper. Okay, to be clear. What happened was that, forget about whether this is a recognizable crime that they did. Okay, but Jennifer Crumbly and James Crumbly were talking about just now. If you're joining the channel, we're just waiting on the Karen Reed live stream to start. So as soon as it starts, I'm going to stream it here as well. In the meantime, I want to talk a little bit about Jennifer Crumbly, because what happened is that there were proffer agreements. Okay, what happened in Jennifer Crumbly's case is that the parents were called to the school. And this happened in Michigan, in Oxford. So the parents were called to the school. They had a meeting with a social worker and I think maybe one of the deans. And at that meeting, they showed Jennifer Crumbly and James Crumbly a picture that their son, the shooter, who was going to be the school shooter in another hour or so, this picture that he drew, and the picture was basically of a school shooting. I mean, that's basically what the picture was. And there, the principal or the dean and the social worker said, yeah, they don't really think there's anything too serious to think about. They think he's going to be okay. Kids nowadays, they see video games, they play video games with all these, murders going on and people shooting everybody else. And just because a kid draws that in school, they weren't too nervous about it. Well, an hour and a half later, that's when the shooting happened. So that's what happened there. Now, those two people, the social worker and the principal, maybe they should be held criminally culpable for that, because they should have realized, hey, you got a kid drawing a murder, basically. What do you think is going to happen? Well, there were some proffer agreements that the prosecution had with these two people. Okay, this is a contract. This is basically an immunity. It was use immunity, which means that anything that they say and testify to during trial, they had lawyers, actually very good lawyers, one of the best lawyers in Michigan in terms of criminal defense. And one of these lawyers, they negotiated this use immunity deal so that the school counselor and the dean can have, and they can talk to the prosecution. And that's what they did. They spoke to the prosecution, and they kind of told them everything that, from their perspective, what happened. And now they're not allowed to use, the prosecution is not allowed to use any of their statements against them. Now, those proffer agreements, okay, this is like prosecution 101. And this is actually a similar issue that we're having in the Karen Reed case now. Okay. So what was not turned over to the defense? These proffer agreements were not turned over to the defense. Now, the Jennifer Crumbley hired a new attorney, very good attorney, by the way. And she originally was represented during the trial by one firm, one attorney. And now, for the appeal purposes, she's hired a new lawyer. Now, they didn't file this appeal yet because they're still filing this motion for an acquittal. They're filing a motion to throw the case out because this was Brady material. Okay, Brady material is not just if it's exculpatory, but also if you can use that information to impeach the credibility of one of the witnesses on the stand. And there's some other issues. There's some other factors that go along with it as well. But that's what happened in that case. Okay, and for all of you just joining now, I am taking a look. I'm watching the Karen Reed live stream, and as soon as it starts streaming, we are going to stream it here. But we're getting a little sidetracked now with what happened with Jennifer Crumbley. Okay, because there will also have a Brady issue, and these proffer agreements were not turned over to the defense. And you can imagine that the cross-examination would have been pretty good if you have these proffer agreements, and something you would have been able to argue to the defense, to the jury, because this is the school counselor and the dean, or I forgot his exact title, they were called as witnesses, and the defense didn't have this material to cross-examine them with. So this is a serious issue. So in fact, this motion was filed, and actually we went through this motion, by the way. We went through this entire motion for either a mistrial or a complete acquittal, and we went through all the different arguments. And this, I think, is probably the strongest argument. And you know what? It wasn't just myself, because the judge herself, Cheryl Matthews, who I know and I've been in front of, Judge Matthews, also, she basically denied everything else of the motion. And then she said, we're going to have a hearing just on these proffer agreements. And there was a hearing that was live streamed with this specific argument about the proffers not being turned over to the defense. And I don't think she made a ruling on the bench. Pretty sure she didn't. She's going to write an opinion about it. But this is a serious issue. I mean, this is like a real problem. The prosecution should absolutely have turned those over. And if they intentionally did not turn those proffer agreements over, that was improper. It just was. So if it was a mistake, and now, of course, they were arguing, it's not material, and, for one reason or another, there's other factors to argue. But that should have been turned over. Those proffer agreements should have been turned over. So we may be looking at a mistrial declared in that case. And then we'll see what happens with Jennifer Crumbley then. She's going to get a new trial. And then James Crumbley is probably going to file the same motion. I don't know. Maybe he did already. Should. So that is what's going on with Jennifer Crumbley's issue right now. And the judge has to make a decision. And this is not such an easy decision for her to make, because they went through the entire trial. And, she probably does not want to have to declare a mistrial. But this is important. How can the prosecution not turn over those proffer agreements? So that is basically a recap of what's going on with the Jennifer Crumbley issue. I should probably do a video on it. Okay, we got also Mama G. Good morning. Good morning, everybody. Hello from South Jersey and Philly. I was actually in South Jersey and Philly last week, which is why I was out of town, but now I'm back. So you guys can see that scale again. And the background's a little bit more normal. I don't have to leave my virtual background where I'm bouncing in and out of the camera. It's not fun. Brooklyn, good morning. And in case you're just joining us now, don't worry. I am keeping track of that feed. And as soon as it starts, we will live stream it here. Lauren McKenzie, hello from London. Deanna from Ireland. We got some Irelands here. So good morning. Nurse Kimberly from Kansas. Good morning from Kansas. I imagine that you're from Kansas from your name, but good morning. And we got a good morning from Jerusalem. Good morning. Some of you may know my sister lives in Israel. Actually, she's coming to visit next week to visit us all because she misses us. So that'll be nice. Ms. Burton, are you hurting Wanda? That's not a joke that I get, but that's the name. Good morning from Kentucky. Chloe's mom. Do you know where Chloe is? Just curious. Apparently she's around, and maybe the prosecution maybe even knows where she is. So good morning. And here's a place where I'd prefer to be right now, Florida. Nancy Hickson. Good morning from Florida. Okay, coming back to Mary, I do agree it was a picture of a school shooting. No, it wasn't a picture of a school shooting. It was a picture, we're talking about the picture that the shooter of Oxford, the Oxford shooter drew. I prefer not to say his name. But it wasn't a school shooting. It was a shooting. It was a person with blood coming out of them and dying very clearly, and pictures of guns and something I think it said blood everywhere. You know, so yeah, there wasn't the name of the school anywhere where they did that. Okay, coming back to the Jennifer Crumbley issue, brother counsel, agree with you completely. What are your thoughts on whether she will get a new trial? I really hope she does. I think it's serious enough to rise to a new trial. I do. How can you not turn over those proffer agreements? I mean, come on. It's improper. It's Brady material. It should have been turned over. I don't know why it wasn't turned over. So we got Noel. Noel, good morning. Good morning. We got Kim. Good morning. And in case you're just joining us now, I am keeping an eye on the feed. So as soon as it starts, we're going to live stream it here as well. So we're just going through the good mornings. If you have any other questions that we can get to before the hearing, that's fine. We know we're all waiting for the Supreme Court to make a decision on the double jeopardy issue. Here we got from Sunny Rob. Good morning from New Jersey. I believe they got it wrong against the Crumbleys. A different charge, maybe, if it stands. Maybe. If it stands, the ruling, in my opinion, sets a dangerous precedent for parents, not just, yeah. And I agree. I was doubtful about this whole issue being charged. You know, it was the first of its kind, and I don't know. It may have been a little bit of an overreach. I'm taking a look at the hearing. I see Karen Reed there. So let's pull it up here. We'll add it to the stage. And you can see what I see. In the meantime, until they get started, we can continue. Oh, Jackson's already at the podium, getting ready to argue. Berkeley, not sure what they're waiting for. Everyone's there. Good morning, Angel Fire. 77 in Palm Beach today. It's like 27 here in Michigan. I don't know what they're doing there. I mean, everyone's there. What are they waiting for? Like the court reporter? Good morning from North Carolina. The Sock Snatcher. And Tampa, Florida, I bet you has nice for what I'm experiencing right now. We got two of us in Jerusalem. All right, two people from Jerusalem tuning in. Thank you. Australia's here. Good morning from Australia. Switzerland. Good morning, Monica. I don't know what they're doing in court there. It looks like everyone's there.
To save me time, does your expert in his affidavit say that this information was erased or that it wasn't there?
Wasn't there.
Okay.
It was erased by an operation of automation.
But do I bother reading your expert's affidavit again so it's not in there?
And I'll address what our concerns are in my oral statement.
All right. I'll hear you.
May I?
Yes.
The court started by asking what is it that the defense is asking for? Basically, we're asking to be treated equitably and fairly. This really is an issue of equity, an issue of fairness. And the court maintains this court maintains the inherent authority to issue sanctions when there is an injustice. And those sanctions can include something like cost-shifting sanctions. And there's a body of law that exists that deals with this exact thing. And that body of law includes the case of the Committee for Public Counsel Services versus the Attorney General. That's at 480 Mass 700. It's a 2018 case.
Well, there you go. You see, remember what I said, that you got to cite this authority. So it looks like they got some authority, which is good. And he's going right to the authority saying how she could grant this. So let's see what the authority says.
The court may remember what was, I think, pretty widely known here in these parts, which was the Amber scandal. Had a bunch of cases going back from 2010 all the way through.
I'm very familiar with the case.
All the way through 2018, and it culminated with Justice Gaziano discussing in his opinion, single justice opinion, exactly these types of things. And what Justice Gaziano said held was, quote, the Attorney General does not dispute that the court has the authority pursuant to Rule 14, sub C, sub 1, to impose remedial monetary sanctions for a discovery violation. And he cites Commonwealth v. Firth, indicating that sanctions may be imposed under Rule 14 for failure to comply with discovery obligations, and sanctions should be tailored appropriately to cure any injustice resulting from a party's non-compliance with its discovery obligations. So the real question before the court today and really the only question before the court today is, has Ms. Reed suffered any prejudice based on blatant discovery and Brady violations by the Commonwealth? And the answer to that question is a resounding yes, she has. Your Honor, Ms. Reed, as the court knows, is on trial for her life, and she's been expending precious resources for some 3 years now, defending herself against provably false allegations. And at the center of that storm of defense are these Sallyport videos. It should be pretty straightforward, really. I mean, it's just a series of videos at a particular location for a particular time. And that time is January 29th, 2022, from midnight until 11:59. It's a 24-hour period, 23 hours and 59 minutes. It should be pretty simple, but it has been anything but simple in this case. We've been asking for a full download of every single one of those cameras and all that footage from January 29th, 2022, from 12 a.m. to 11:59, but we've never gotten it.
When did you first seek it?
We asked for the preservation on February 2nd, 2022, when Mr. Yannetti said retain and maintain all physical evidence. We've been seeking these videos since well before the first trial. We didn't get them before the first trial.
Do you have a date? Do you have any chronology for me?
I don't. I can certainly provide those, but it's been.
I'd like that. I mean, that would be.
I'll be happy to do that. It's in discovery request after discovery request after discovery request. Basically.
So basically he's saying Yannetti's been asking for this from the beginning, within a month, but less than a month. He was asking for the preservation of those Sallyport videos, and in all the discovery requests, he kept asking to provide, well, he wrote copies, but provide those videos. So definitely the preservation part. He made a motion for that right away, early on.
There's also a catch-all. We've been asking for all physical evidence concerning video footage from Canton PD from well before the trial. We didn't specify which cameras because we didn't know which cameras had video footage. We didn't know how many cameras there were, but we didn't get anything from the Commonwealth. And I'll address that in particular in just a second. Mr. Lally didn't give it to us before a full download before the trial. The Commonwealth didn't provide it during trial. And today, as I stand here, we still don't have it. And interestingly, Mr. Brennan does make mention in his opposition that, quote, at no time has the defense ever made a formal preservation request. I found that interesting for two reasons. And I have two comments about that. First, as the court record reflects, on February 2nd, 2022, I just referred to it, Mr. Yannetti filed a preservation demand for, quote, all physical evidence to be maintained. That DVR, the footage on the DVR, is physical evidence that was required, not requested, but required to be maintained by the Commonwealth pursuant to that demand. But second, and this is probably more important, it wouldn't have mattered if we didn't ask for it to be maintained. It wouldn't have mattered if we didn't ask for it to be preserved. This was a self-executing duty by the Commonwealth. As Justice Gaziano said,
and that's something exact that we spoke about. You know, regardless of whether Yannetti made a request, whether he made a formal request to preserve the evidence, the prosecution is required to preserve that. You're required to preserve it and disclose it. to the defense without them doing anything. They can sit in their office with their feet up, and they should get a knock on their door with all this evidence. So he's just talking about, the fact that Brennan said in his response that the defense never made a formal request, first of all, is wrong. Second of all, it doesn't matter. It absolutely does not matter because they have to preserve it and disclose it anyway. And now he's just going to cite some authority to that effect.
Stated in the same case, the Committee for Public Counsel, quote, a prosecutor's core duty is to administer justice fairly. To fulfill that duty, a prosecutor is required to turn over exculpatory evidence to a defendant without regard to its impact on the case. The failure to disclose evidence favorable to an accused that is material, either to guilt or to punishment, is a violation of due process. Litigation strategy plays no role in this process. Under our rules of professional conduct, a prosecutor is required to make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate guilt of the accused or mitigate the offense. And he cites Massachusetts Rule of Professional Conduct 3.8 subsection D. The Commonwealth's Brady obligation is self-executing, Your Honor. It wouldn't have mattered one whit if we didn't ask for that footage, but it turns out that, in fact, Mr. Yannetti did ask that it be maintained. And the Commonwealth has still failed to preserve it. What we have gotten, it appears, are scraps and fragments of videos that the Commonwealth has decided on their own, within their own time frame to dole out to us over the course of months and years. And included in that scrap and fragment was a video that was missing 42 minutes. The court is well aware of this video. It was heavily litigated and heavily referenced at the first trial. That's the exact time frame. The missing portion is the exact time frame that the SUV was being pulled into the Sally Port. We got that video on April 4th, just days before the first trial. Keep in mind, it's a video from January 29th, 2022. Another one of those videos was the inverted video that has now seen some fame, that the Commonwealth tried to sell to the jury as a true and correct copy of a video within the Sally Port, and we got that one after the trial started, in the middle of trial. So why were we getting videos from January 29th, 2022, 2.5 years later? And why were some of those videos altered or manipulated and not in their proper format? We still don't have answers to those questions. And literally, while we're asking that question and while we're pondering that question, a couple of days ago, we're getting yet more videos, scraps, piecemeal. We got another Sally Port video just a few days ago, this one showing the Lexus backing into the Sally Port from some exterior camera. And that also is exculpatory evidence. Mr. Brennan writes in his opposition that the idea that the defense has been misled or was misled in its efforts to try to go secure that DVR footage is a distortion of the facts with, quote, no legal merit. Really? A distortion of the facts with no legal merit? Where's all this footage coming from, if not the DVR? It's the only place it was held. It's the only place it was captured. So of course we were misled by continually getting these piecemeal snippets of footage from the DVR, from the very source. Had to have come from there, coupled with the Commonwealth saying, and Mr. Brennan saying, yeah, come on out. You can have your expert come out, meet us at Canton. We'll provide the DVR. You can have him look at it. He can bring his equipment, download whatever you want from that 24-hour period. So what were we to believe? That it was on the DVR. It had to be. How else were we getting these piecemeal videos? And they've had that DVR for 3 years. They knew exactly what was and what was not on that DVR. They had to have. This has been the center of a storm that surrounded this case from the jump. And to claim otherwise, it's just patently absurd. So Mr. Brennan also wrote in his opposition that Mr. Jackson said, don't touch the DVR, don't mess with it. So I informed Chief Rafferty, tell your staff, don't touch it, don't mess with it, almost suggesting, intimating that it's my fault that we didn't know what was on the DVR. That's absurd also. How am I supposed to know what is or isn't on the Commonwealth's DVR? What I actually said, that was a sort of a liberal interpretation of the facts. What I actually said was, Mr. Brennan, do me a favor, if we're going to come out there, just don't have anybody download it in advance. Let's do it all together when we're all in the same place. That's what I said, and he accommodated that. He said, sure, we'll agree to that. So based on this history of getting these small clips from January 29th, we knew there had to be more footage. So when Mr. Brennan came on board, we made the request to him as well as the requests that we had made to his predecessors. We want all the footage for that 24-hour period. And lo and behold, we started getting more clips, more snippets, more piecemeal bits and bytes from that DVR. And one of them was a clip of Brian Higgins standing out in front of Canton Police Department in the parking lot in the freezing cold at 1:35 in the morning on January 29th on his cell phone. To punctuate the importance of that video footage, recall that this issue was raised at trial. We talked extensively. When I say we, both the Commonwealth and the defense, me in particular, spoke with Mr. Higgins about this issue. It was raised at trial, and Brian Higgins never once, not once, on direct examination or on cross-examination, admitted to having made a phone call in the middle of the night on January 29th. And yet now, after the trial, we get a video of him doing exactly that. And that also proves that he lied in front of a federal jury, in front of a federal grand jury, when he testified that he didn't have or make any phone calls in the middle of the night. That is called exculpatory evidence, and that's Brady evidence, and it was withheld in its entirety during the first trial and for the last 3 years. And it's against that, the reason I bring that up, Your Honor, it's against that backdrop that we then say to Mr. Brennan, kindly give us the footage. I don't want this piecemeal thing to keep going on. Just give us the raw footage. We'll send an expert. So the plan was put in place, and experts were retained, and flights were booked, and hotels were reserved, and transportation was arranged, and all at Ms. Reed's expense. She's writing the check for all of this. And our expert flies out to Canton, walks into the room, and within 10 minutes, they open up the front plate of the DVR, and lo and behold, Commonwealth says and agrees, oh goodness, there is no footage. It was overwritten within 30 days. What? How could that possibly be? So the expert calls me, Mr. Jackson, what do you want to do? And I said, I don't know. I'm not a tech. That's your job. I don't know what to do. If it's overwritten within 30 days, I don't know. Maybe there's a log. Let's find out who has access, whose digital fingerprints were on that DVR, who downloaded the footage, when it was downloaded. What about these clips that we have? I'm very confused. So the expert goes back and says to the technician for the Commonwealth, Colleen Crawford, well, let's at least download the log. At least we can have access to that, and we can start unraveling what's going on here. Oh, sorry, that's been overwritten as well. There is no log. You get no footage, you get no log. This was a complete and utter waste of time. According to the Commonwealth, that system, as I said, overwrites every 30 days. So by February 28th, I counted them, by February 28th, 2022, every single frame of that footage should be gone. So how did we get the inverted video in April of 2024? How did we get the video clips of Brian Higgins in October of 2024? How is that possible? The only explanation, Your Honor, is that the Commonwealth downloaded the entire system within the first 30 days. Otherwise, it's gone, admittedly. And all of that has been withheld from us for 3 years. Then to add salt to that wound, the Commonwealth allows us to go on this wild goose chase, spend $12,000 some odd dollars of Ms. Reed's money, and fly an expert out to Canton for absolutely no reason, zero. The 30-day overwrite protocol is something that their technician absolutely would have and should have and did know before we ever set foot in Canton. She was well aware of exactly why we were going out there. We were going out there to download footage from 3 years earlier. She knew it, we knew it, Mr. Brennan knew it, everybody knew it. But within 10 minutes of walking in the door, it was revealed that there, in fact, was no footage. And that's a fact that the Commonwealth had to have been aware of for the last 3 years. Yet Karen Reed is the one having to foot the bill for what turned out to be just a snipe hunt. It's not fair, and the Commonwealth should reimburse her for this fool's errand that was not of our making, of her making. The Commonwealth has since told us, Mr. Brennan told us, that remarkably he went to Canton PD, and this is in his opposition paperwork and his declaration, and he spoke with some officer. And that officer told him that he, the officer, personally made a copy of the entire January 29th video footage and placed that copy in some sort of an iCloud account. Not on the DVR system, not in the official data bank in which it's supposed to be stored, but on some iCloud account. And we're finding out about this in 2025. It's outrageous. What it is this entire situation surrounding this DVR and the Commonwealth's maintenance of that DVR and the footage on it is a complete dumpster fire and Ms. Reed has to pay for the fire extinguisher. And that's not fair. The High Court and the Committee for Public Counsel, the same case that I referenced a little bit earlier, and the court will know this because this was sort of the big takeaway from that case is Justice Gaziano fashioned a cost-shifting remedy against the Commonwealth and for the defense. And that included the entire cost of investigating and locating and contacting nearly, I think it was 10,000 defendants. It was an enormous amount of money and an enormous undertaking. And the Commonwealth had to foot that entire bill. And the reason they had to foot the entire bill is because the Supreme Court decided that it was prosecutorial discovery violations and cost-shifting remedies were in order. We're asking absolutely no more than that from this court. Fairness dictates that Ms. Reed be reimbursed. And I'll submit, Your Honor.
All right, thank you very much. Mr. Brennan?
It's notable that the defense purposely conflates two very separate issues. If you had a chance to read their motion, they suggest that they should receive costs because they hired an expert, came to Canton, and didn't receive the information they wanted. Yet today in the argument, they try to give you a historical complaint about the production of videos in this case. That is a separate issue. That's a Rule 14 issue, but that is not the motion before the court. The reason I suggest they conflate the issues is because they know their merit for costs. I mean, their motion for costs has no merit whatsoever. And so what they're trying to do is incite facts, invoke this injustice they've created so that the court looks at the motion that they actually filed and gets it distorted. It is disappointing to stand before a court and file an affidavit as an attorney and have someone else have a cross affidavit. Frankly, in my career, when that has happened on rare occasions, I find that embarrassing. There is very skilled and able attorneys in this courtroom, and to work out discovery matters and agreements is something that attorneys always should do. And that is what I've tried to do in this case. I have tried to give the defense the best opportunity I can to get whatever information they want, whether it is required or not required. Yet, I'm standing here today and I have to now share with you my conversations with the defense. I have to share with the court my position, which is contrary to the defense, because they have lodged a motion asking for money that they are not entitled to. If I stand back and do nothing and remain the dignity of the court, then what happens is there are claims that just float out in nowhere, and a lie unchecked becomes the truth. So now I must stand before you and I must tell you what happened. When I entered this case in September and I began to look at discovery, I saw a video produced in August from the Canton Police Department, and we immediately turned it over to the defense. I began a study of the case and tried to articulate and account for all evidence and make sure the defense obtained everything that they were entitled to and more. The defense asked me to try to account for the video because they believed it had been an issue in this case. I looked through the docket. There was no motion to preserve videotape. I read the pleadings. Attorney Yannetti was meticulous in his motions to preserve. It was admirable. It was meticulous, the work he did. There was no motion to preserve, and that has some import. It doesn't relieve the government of their obligation to provide Rule 14 discovery or exculpatory evidence or Brady evidence. It doesn't relieve the Commonwealth of their obligations to be dutiful, but it is difference in kind. Because the defense, if they want something that is not obvious, they put the Commonwealth on notice. Having practiced for almost 3 decades, you file motions to preserve within 24 hours, 48 hours, or 30 days. And so when Mr. Jackson called me, Attorney Jackson called me, and he said he wanted to come out and bring an expert to look at the NVR or DVR of the Canton Police Department, I had never seen that in 30 years. It's not part of our obligations. He's not entitled to come into the Canton Police Department with his own experts and download his request. But in the spirit of transparency, in an effort to help the defense so there will be a fair trial and they can obtain all the discovery, understanding the history of this case, seeing that there was an August videotape post-trial, I wanted to do what I could to accommodate them. So without any hesitation, despite that there was no court order, no motion to preserve, I invited him to come to the Canton Police Department. I called the chief of police. I asked the chief of police, although this was unique and novel, unprecedented.
I wonder if it's unprecedented that you get videos that are inverted. And I wonder if it's unprecedented if you get a video right before trial, when you had the video for a few years. So as much as he's arguing, oh, this is so unprecedented. Well, what about all the other things in this case that are unprecedented? Maybe that's why they have to start doing these type of things, because nobody can trust what you're turning over. But anyway, let's continue.
Could the defense come and access their material? Typically, the Commonwealth will download it and provide them a copy. She had no hesitation. So I called Attorney Jackson back and I said that we would allow it. Attorney Jackson expressed concern, understandably, being a defense attorney, that almost 3 years later, the video may not be on the NVR. I had the same concern. I want all of the evidence. I'm not looking for evidence that's good for the Commonwealth or helpful for my case. I want all of the evidence. And so after he expressed the concern, I made clear I had no idea what, if anything, was on the NVR. We could go and look at it, but Mr. Attorney Jackson didn't want that. He wanted his expert to be the person to open the NVR. And respecting his position, providing a professional courtesy, I agreed. Didn't mislead him. I didn't think there would be video. I had no idea. So Mr. Jackson, Attorney Jackson, pardon me, sent out his expert. And by the way, the expert that came was not the expert they designated. I got a call because we were in court on a hearing that they had sent a different expert they hadn't noticed. And my response was, it doesn't matter. Whoever they send, let them look at it. And so when they did.
But again, he didn't have to open up the DVR for their tech person to know that it's overwritten every 30 days. If that's like common knowledge in the police station, it's common knowledge. Everybody knows it. The tech people know it. You don't have to open up the DVR to know that. They can say, listen, Mr. Brennan, I know that Jackson wants to send his own expert here and he doesn't want us to touch it, but we can tell you absolutely with certainty, that is overwritten every 30 days. And tell him he's wasting his time and money. That wasn't done.
Not surprisingly, the information had been overwritten. Now, while there was a 30-day override on that machine, I believe the defense expert knows that there was a backup hard drive which kept materials longer than that 30 days. I do know that there was materials on that DVR, NVR, back in July of 2024. And I know that from a report that was generated by the Commonwealth and given to the defense. So they should know that as well. That may be one reason why they wanted to come out. They came out on their own volition. I extended the courtesy as much as I could, made no promises. I was clear, I was very uncertain about what would be on there since I never looked at it. After I learned there was no information on the NVR, I took the initiative and went to the police department. I viewed the police department, the cameras, I spoke to personnel and I spoke to the retired individual who then was responsible for providing video upon request. And when I spoke to him, he told me in conversation that he would routinely store a copy on a file he noted as a detective file or on his hard drive. That was news to me. I thought that was helpful, so I notified the defense about my conversation. I was not trying to lure them back to Canton or have them spend money. I was trying to, as I always do, be as transparent as I could and as helpful as I could. Now, what I simply should have done and could have done is I could have gone to that detective file and downloaded the video and given a copy to the defense. That's my obligation, no more. But I didn't. I extended the courtesy that if they wanted to come and look at that file before we opened it, so it could be beyond reproach, they were invited to do that. I wasn't encouraging or luring them. I was inviting them because they'd already been part of the process. I thought it would be disingenuous not to let them.
And again, here you have another officer, another person who allegedly has a full download and copy of this on some server somewhere that no one's ever found out about until today. It's just unbelievable that this keeps happening. Oh, there's some more information that you don't know about 3 years later. Oh, there's some more information. And there's another guy who knows something. There's another guy that has some sort of evidence that could be very, very extremely helpful and exculpatory for Karen Reed. Whoop, just forgot to tell you about that. I mean, it's just unbelievable. It's more and more and more.
Participate. And what they told me is to wait. So now that information, whatever it is, I don't know because I haven't seen it. And I've asked the detective or the retired detective not to access it. It is sitting in that file supposedly. So at this point, it's the Commonwealth's position that we are going to go and download that information to give a copy to the defense. The defense waited almost 3 years. The defense was very clear about my uncertainty would be on that tape. And now they stand before the court and they try to parlay this into some type of injustice for their cause. The case they cite, Commonwealth versus Frith, the district court was overruled in assessing costs because there was no egregious violation. This is not a Brady case. This is not a setup. This is the government providing information as the case progresses and evolves and changes and retools. So what we have now is information, supposedly, on a database that we are going to get and give to the defense. You should deny their motion. Nobody was misled in this case. They've taken a professional courtesy and an effort to help, and they've distorted it into some type of injustice. The Commonwealth's not going to be distracted from the cause in this case, which is a trial on April 1st. The court should not be distracted from the cause in this case. If they have a separate motion about Rule 14 violations or motion dismissed for misconduct, that's a separate motion. That's not the motion before the court today. The motion before the court today is to attempt to recover costs for something they chose to do and that I accommodated. It should be rejected. Thank you.
Any quick response, Mr.
Very,
Jackson?
very briefly, with the court's permission.
Sure.
By the way, it is a Brady case. There's no question that the data on those videos are Brady. They're exculpatory. That's where we start. So Mr. Brennan can say all day long, that's not a Brady case. Don't worry about it. Let's just sweep this under the carpet like we've done everything else. It's there's nothing to see here. That's not true. It's a Brady case because the information that we have now received from that DVR, that NVR system, is exculpatory to Ms. Reed. That's why I cited
Brian Higgins part?
That's why I cited the Brian Higgins part. Correct. And I suspect there's a lot more on there as well. The inverted video part is also Brady, which we got in the middle of trial. Mr. Brennan says, basically, his argument is, deny the motion because they took a courtesy. I'm trying to be courteous. And he's a gentleman. This is not personal to Mr. Brennan. He seems to, the tone of his responses was, well, this is personal between Mr. Jackson and Mr. Brennan. It's not personal at all. This is about the defense and the Commonwealth. It's about Ms. Reed and the Commonwealth. But let's not conflate a courtesy with an obligation. The Commonwealth has an obligation. I don't care that Mr. Brennan wasn't on the case previously for the last 2.5, 3 years. It doesn't matter to me. This is not personal to him. I appreciate the fact that when he came onto the case, he immediately found in August, he found a video that had never been turned over. I can't fault him for that. He turned it over when he found it, apparently. What I can fault is the Commonwealth. Mr. Brennan was brought onto this case not to represent Mr. Brennan, but to represent the Commonwealth. And all the foibles, all the warts and blemishes that preceded him, unfortunately, are now his responsibility as lead counsel for the Commonwealth. He indicates that when he found out that we wanted to come look at the DVR, and we have absolutely no right to look at that DVR, this was just a courtesy, et cetera. Well, that might be true if we hadn't made the request because we had been getting piecemeal videos from a DVR system that supposedly was overwritten.
So the oral request by phone call you're talking about?
The latest one, right. So my request to come out and have an expert come out and see it. That's not just a courtesy. That's just good lawyering on his part and mine. You want to keep your hands clean, let's do it the transparent way. Have everybody come, bring their experts, whoever they might be, and let's download this stuff together. So there's no funny business, and everybody can wipe their hands and say, I didn't have anything to do with it except downloading the material, and whatever that material is, it is. That's just good lawyering. It's not a courtesy. He was doing that to protect his own and the Commonwealth's interest, and it was quite smart until he realized, because he didn't have any way of knowing it any more than I did, that there was no footage. It had been overwritten. Perhaps, certainly the defense was deceived. Perhaps Mr. Brennan was deceived as well. He indicates that he contacted Chief Rafferty, and she said, with no hesitation, yeah, bring him on out here. I wonder if that lack of hesitation had anything to do with the fact that the chief knew that there was no data on the DVR. You can come look all you want to. The bucket's empty. I have no idea about this iCloud account or who owns the iCloud account, why this data on January 29th was moved from the DVR to the iCloud account. Mr. Brennan did say, do you want to have your expert come back out and watch as we download the iCloud account? I said, let's defer that because this is literally, these are the contours of motion that's going to be before the court. And I still want to defer it because what I didn't want to do is pay another $12,000 or $15,000 for a second bite at this apple just to find out that iCloud account is somehow compromised as well.
Can you have someone record it? Can you have somebody that it won't cost you $12,000 if you want to come out and just have someone record it as it's being done?
Sure, I didn't interrupt the court. Yes, I can certainly make accommodations other than flying an expert out and having somebody do it in person. That may be an option that we exercise. I may talk to Mr. Brennan about that because I still want to have some transparency on that process. But what I don't want is to throw good money after bad at this issue when she's already spent $12,000, $12,200 and something dollars for absolutely nothing. This is not a matter of courtesy. This is a matter of obligation. This was a matter of Brady. It's no different. And by the way, the case that Mr. Brennan cites, he indicated that I cited that case. I didn't cite that case. Justice Gaziano cited that case in his opinion in the committee case. And the ultimate opinion of that court was when there is a discovery violation, when there is a Brady violation, and there is no question that that's what's before this court. Blatant discovery and Brady violations. The Commonwealth doesn't, the court may remember, by the way, on the witness stand when these videos were coming in piecemeal, especially the inverted video, 2 or 3 witnesses all went like this. I wasn't the one told it. I wasn't the one that downloaded it. I wasn't the one that downloaded it. I don't know where it came from. It just ended up on my desk on a flash drive. I don't know where it came from. Everybody was pointing fingers at everybody else. Nobody could establish a single chain of custody for those videos, and we still don't have it. So Chief Rafferty's statement, yeah, come on out, no hesitation whatsoever. They can come look at it. I suspect it's because she knew it wasn't there. This was we were led in a circular runaround, and it was ultimately at her cost, and that's what's.
So didn't the two of you, when you talk about good lawyering, didn't both of you agree that it was highly unlikely it would still be there? Or are you saying that part's not true? Mr. Brennan told me that.
I said, I'm concerned if we don't get out there fast. I don't know what the override protocol might be. So yes, I was concerned, but who cares? Well, that's no legal moment. What I thought and what Mr. Brennan and I discussed 3 years after the fact, when the Commonwealth has a self-executing obligation to provide that information to us because it's Brady. They also had an obligation pursuant to Mr. Yannetti's demand, not request, but demand to maintain that information.
So where is that demand? Is that in the file? Where is that demand?
February 2nd. I don't know what the docket number is. It was filed on February 2nd at her arraignment.
Here?
Wherever the arraignment was, Mr. Yannetti.
It was in the Stoughton District Court.
Okay.
But it's part of the case file. And it stays with the Commonwealth, and that obligation stays with the Commonwealth. But I would propose to the court that even if the court's concern is, well, when was that filed, and did Mr. Brennan
No,
actually?
I haven't seen it. I know it's not part of our file, and you're talking about it as if it were here.
Your Honor, I can't say with certainty, but I believe that it may have been submitted as an exhibit to a previous motion, probably early on in this case.
Okay, I
so-
just wanted our record to be clear.
Of
You're
course.
talking about Mr. Yannetti filed this. You did not file it in this court
I may have filed it as
as an
exhibit.
attachment, but it was
but
never
not-
any.
Right. There was, I don't mean to cut off the
No,
court,
no,
Judge.
it was never brought before me or a judge who had this case before me to be heard.
So there was early on, and so many motions have been filed in this
Right.
case, but early on, I did bring a motion, I believe before Your Honor, asking that all of the Stoughton District Court motions that I had filed at arraignment and thereafter be ratified by this court.
Okay.
That is in our record.
So I need you to find that
Happy to do it.
and tell us when it was filed, the act. I need to see
By
that.
the end of the day today, you will have whatever submissions we provided, and if it's not part of an exhibit, you will have that motion.
All right. Go ahead,
Just
Mr. Chair.
to answer that one question that I can't answer because I've seen the filing. It was filed February 2nd, 2022, court stamped. My point is, even if that weren't the case, and it is the case, the obligation is self-executing. That's what Justice Gaziano was talking about when he talks about in the committee case, the self-executing duty that a prosecution has or a prosecutor has to maintain and preserve exculpatory information and provide that information to the defense. They didn't do that. And they led us to believe every single sign and signal, irrespective of what Mr. Brennan did or didn't actually personally know. The Commonwealth's conduct in this case, from the beginning of the investigation to now, suggested that that information existed, the DVR existed, the video footage on the DVR existed, and we were going out there to download. We shouldn't have had to jump through this hoop and go on this wild goose chase at Ms. Reed's expense. It is not, I think we can all in this courtroom agree, none of this is our fault. We didn't do any of this. It's all on the Commonwealth's shoulders. It's all their responsibility. They should have to pay for what happened when we went out there for absolutely no good reason. And I'll send that.
All right. Mr. Brennan, I have just a couple of questions.
Yeah.
So you don't know for certain whether this information was in fact downloaded onto the hard drive, but you suspect it is based on your conversation with the named gentleman in your affidavit?
So there's two different systems. One's called the DVR, NVR. That's the actual system that keeps all the footage that's recorded. That has been
That
searched.
commonly is overridden every
Yes.
30 days,
Like has been overwritten.
statewide police departments.
Yes, Your Honor. And
Okay.
that has been overwritten,
Okay,
and there is no information on that.
okay.
When I spoke to the retired sergeant detective who had downloaded video, he said as a habit, he would routinely, when he would make a video copy from the DVR, he would place it in a separate file. I can't say that it's exhaustive. I can't say that it captures all of the video. It's when he would make a copy. And it seems in this case, there were select copies made. It doesn't seem that there was ever a time when somebody just copied the entire event. Now, the issue of whether there was a request for it, the obligation of the Commonwealth, I think is a separate issue. What exists on his hard drive in the detective file, I don't know. But what he has told me is he would routinely make copies of what he would provide to the court and the Commonwealth, or the Commonwealth and defense, and he would put on that separate file. I don't expect, and I'm only guessing, that it's going to be an exhaustive copy of the entire night of January 29th, 2022. I don't expect that. I expect it will be a copy of whatever it is that he has provided in this case. And so I think before it just lingers there forever, it should be copied and it should be provided to the defense.
All right, so I do want you and Mr. Jackson to talk about whether within the next week you do have somebody video it, or at your expense you send somebody out at it, but let's get moving with that. I know you said you'd make a download a copy and send it.
It's really unbelievable how long after January 29, 2022, evidence is all of a sudden showing up. It's really unbelievable.
Are you satisfied with that, Mr. Jackson, or do you want to have someone there while that occurs?
I at least want to noodle on that for a second, but I'll talk to Mr. Brennan about it.
All right, I'd like it done within the week. The person has to be there within next week, or the Commonwealth will download it. We've got to get this case moving, and you want it, so it's got to be provided.
The stall isn't my fault. Yes, we want it. That's why we asked for it in the first
Yeah,
place.
so let's try and work it out before you leave here today, okay?
Sure.
Arnett, I'm happy to defer at the defendant's request. I'm prepared to do it now. If they want me to wait, if they want to have somebody there, I'm receptive, but we're ready to do it now.
All right, so I'm telling you to please wait, work it out, but no later than next week.
I understand.
All right, thank you. Did you want to be heard further? in
Briefly,
response?
Your Honor, although I've come into this case late, I am the Commonwealth, and I assume all responsibilities of the government's case in the history of it. This motion is not about a Rule 14 complaint or a violation. If the defense has a motion for sanctions or to dismiss, whatever the remedy is, because they think they've been agreed, that would be a different motion. This motion is they're trying to get the court, or asking the court, to impose costs because they had their expert come out at their request, and they were very clear about the risk associated with that. This motion should be denied. If there's a separate motion, we'll deal with that when it's filed. If I had known that the defense was going to argue something entirely different, and that is the failure to preserve, I would have made a copy of all Mr. Yannetti's motions and requests, and I would have provided them as an exhibit. But I did not do that because that was not the scope of this motion. This motion should be denied.
All right, thank you very much. Taking this under advisement. And do not wait for a decision from me on this about whether or not you send somebody out to
We
get
won't.
that video.
We'll get started on that immediately.
All right. All right. So let's move on to the Commonwealth's motion for clarification regarding the search warrant. Or the contents of the defendant's phone, more accurately. Please.
In reviewing the discovery in this case, I learned that there was a search warrant for Miss Reed's phone. That search warrant entitled the Commonwealth to search for data that's outlined in what's known as addendum or attached as addendum A. Learning the history of this case, I further learned that because there was an assertion of privileged communications, there was an agreement that the Attorney General's office would look through the data on the communications, and they would identify any attorney-client privilege information, extract it, and then provide the information back to the government and the defense. I am not sure of the accuracy, but I learned or read that the defense was given an entire data copy, forensic download of Ms. Reed's phone years ago. When I looked through the discovery, it surprised me that the Commonwealth did not receive the forensic data. It received a report. And when we reviewed the reports, it had references to navigation information and Google searches, but did not have any of the forensic download. And so clearly, the Commonwealth has a warrant, is entitled not only to the PDF extraction, they're entitled to the full force of that proof, which is the data. I spoke to my experts, and they advised that they believed that the data would have more information than simply a PDF. And so when I learned this, I wanted to both scrupulously protect the defendant's rights, but I also wanted the data for our review. And so I limited my request for the data to navigation information in the Google searches. Although I do not believe it was required pursuant to the communication protocol, I asked the Attorney General's office to engage in that protocol anyways, just out of abundance of caution and respect to the defense. I contacted the defense. The defense offered their objection. I think it has no legal merit whatsoever. They don't have standing at this point, but I noted their objection. I believe, without certainty, that the Attorney General's office has gone through that review to make sure there are no communications. However, they expressed some reluctance to provide the information because of the existence of the communication protocol, and they did not believe there was enough clarity that there was a distinction between navigation information. I do not see that navigation information, Google information, or the other data that I want is covered by the protocol. I believe that protocol has at least partially already been followed anyways. Time is of the essence. This case is on for April 1st. There is what I believe to be relevant material, important information, including Google information and navigation information that we are entitled to. I don't want delay. So I filed this notice so that the court could give direction, either assuring the Attorney General's office that they could provide the information, or if there is going to be a protocol, which I discourage, that it's expedited. If there is something the defense wants to look at prior to me receiving it, it should be on a very, very narrow time frame. I don't think they have a right or entitlement to review anything I get. I think the Commonwealth is entitled pursuant to the search warrant. If they have a remedy, it's after we've already reviewed it, not before. And so I'm doing this to facilitate things because I'm mindful of the April 1st file, and we will pursue this information and use it if relevant.
Okay. Is there an opposition? I don't have anything in writing.
Your Honor, not really. The only thing that we expressed to Mr. Brennan was, and maybe I misunderstood his first, it was a communication we had on the phone. I thought that he was seeking something far broader than the search warrant. It sounds like he's staying within the parameters.
It sounds squarely within the search
Right.
warrant.
So that doesn't bother me. I want to make sure that whatever information he gets is squarely, as the court just said, squarely within those parameters. January 28th at 9:30 p.m. until January 29th at 5:30 p.m. And otherwise, I don't disagree that pursuant to the search warrant, we can get the. I'm calling it raw data, but I think we all know what we're talking about. Not the PDF, but the underlying data.
All right. It's squarely within the search warrant.
Right.
I do feel Mr. Brennan did not have to come to me or even you with it, but I do appreciate that you did so. So yes, so the AG's office knows that you are entitled to that information. You may have it immediately.
Thank you.
Okay. All right. So the motion regarding, just want to get Commonwealth's motion for reciprocal discovery pertaining to employees of ARCA. And then if you go one step further than that, are we going one step further than that with the second motion today? Or do council want to come to sidebar and tell me any information you have? Or how do you want to do this?
Whatever the court's most comfortable with. I'm
I'd,
an open court or sidebar.
I'd prefer to find out what's going on over in federal court at sidebar first.
Yes, Your Honor.
Wow. So very interesting. Okay, I have not been paying as much attention to the chat as I probably should have been. I'm doing this, but I mean, this is an important issue. I was concentrating 100% on that and taking notes. So if there's anything that you guys want to put in the chat now for questions, I'll see what I can do to answer them. But right now they're moving on to the ARCA issue. Remember what the ARCA issue is. The ARCA issue is that Brennan wants specific information about the ARCA experts, which most likely he's not able to get, and the defense is not able to provide. And that's just going to set up his next motion to strike them. That since there's these Rule 14 violations, that they cannot get certain information on the ARCA experts. So even though the defense did nothing wrong, but if you can't get that information, they're going to be arguing that they should not be allowed to testify. So that's, I think, leading up to his eventual motion on that. So I think that's probably what they're discussing on the side there. Let me see. I'll try to go back in the chat and see if there's any questions here. And by the way, I know some people are talking about Alec Baldwin's case. And what was interesting there is that actually there was a special prosecutor that was hired. And that special prosecutor, Carrie Morrissey, brought in a different special prosecutor to help her. And when that special prosecutor realized some of the Brady material was not turned over, she left. She said, "No, thank you," in the middle of the trial. If you guys remember that. And she left. She says, "No, I'm not getting involved with these shenanigans. Like, I have a reputation." And, so if Brennan wants at any point, he can say, "You know what, guys, I mean, this is just, it's getting to a point where we're all of a sudden finding things that are exculpatory that was not turned over. And this can really, this is not fair." Okay, let me see what else we have here. Here, Sarah H., is this not enough to dismiss the case? Well, we are going to be seeing that motion. And this is very, this is Brady material. It could be significant enough to dismiss the case. If you have Brady material that was not turned over and exculpatory, that Sallyport video, if you're able to see that taillight on the Sallyport video in that Sallyport, and it shows that there's only a little crack in her taillight, then 43 pieces of that taillight were not at the scene at that time. That's 100% exculpatory. So, yeah, that could dismiss the case. That's enough to rise to Brady violations. That's bad enough. It's just unbelievable how much, more and more stuff just keeps coming up. It's just. Here's an interesting question. Nene King, how different do you think this trial would have been with Judge Marlo Summer at the helm? Opinion by the counsel. Judge Marlo Summer was the judge in Alec Baldwin's case. And she was an absolutely no-nonsense judge. She may have not been as liberal as Judge Cannoni is being on these issues. And again, we're going to see that motion to dismiss. They're going to file it. I think it has to be filed by February 11th of next week. And we're going to see all the issues that they're going to be raising in that Brady motion. So some of them we know about, and we've spoken about. Some of them I can't think about right now on the top of my head, but it's going to be a very interesting motion. Most of the time, these motions are denied. It's just the way it goes. And we'll see what eventually happens with that. Joanna Kane, what legal reasoning will above use to deny the motion to dismiss? Well, the reasoning is that she may say is that, you know, dismissal is the most severe sanction. If there's any other way to go about it, then you know, that's what you have to do, and that's what the courts encourage. They don't encourage dismissal; they encourage findings by juries. You know, all that stuff that we hear all the time. Dismissal is a very, very strong sanction, and you know, they're encouraged. Judges are discouraged from dismissing cases. Again, if something rises to dismissal, like Brady, like if this, you know, like if you can actually get the material at some point, okay, now you have everything. There's no nefarious conduct. We did everything that we could to preserve it, and this is the best that we have, and this is the video, and now we're turning over everything over, and you have everything now in front of you, so you can use it in the trial. You know, you can kind of make the argument that, okay, well, you know, you need more time to think about the Brady material. You want more time to prepare your cross-examination. Okay, we'll delay the trial a week, 2 weeks. But flat out dismissal, no. But if there's the whole issue with this video is that they can't trust the copies, because every time they get more copies, one's grainy, you can't really see it. All of a sudden, in the middle of a trial, they get a clear version of the video, a new video, and it's missing parts. So, you know, what type of copy can you trust? Here, Just Joe, does it have to be exculpatory or just any evidence relying on one person to decide doesn't seem right? Yeah. Well, in order to get a dismissal, it's got to be Brady material, which means it has to be exculpatory, or it has to be something that you can use to impeach one of the material witnesses. So in order to rise to the level of dismissal, it has to be significant evidence, not just, oh, we forgot to turn over this evidence that really is non-consequential. By the way, hi from Waterford, Michigan. My home state. And here's the point. Rose with a Bohm, it could also be inculpatory. That's true. If the Lexus came into the Sally port and it's completely smashed, yeah, that, you know, that could also be inculpatory. Both ways. By the way, we got another Michigander, Cy Botson. Good morning from Oakland City, Michigan. I think it's Michigan, right? Yeah, Michigan. Look at this comment from Sam. Funny, I work for a company involved in a frivolous IP lawsuit, intellectual property, and my computer has been on legal hold for 4 years of delays and motions. You know, so they actually confiscated his laptop, his computer, and until the case is concluded. But apparently, in this case, you got some people downloading stuff on computers and iCloud, and nobody ever knows about it. Nobody knows where to find it. Here's SP74. So this is video that goes beyond what we've already seen? Well, that's the question. Maybe. And if it wasn't, well, maybe it was deleted. And if it was deleted, where's the log? Who's the last one who touched it before it was deleted? That can give us indication if a person modified it or changed it or deleted it. Here we go, Jesse Pink. If the taillight was smashed in this video, you think the prosecution will want the video in ASAP? Exactly, they would. So does that mean that they that it doesn't show that, or does it mean that they just never got a copy of it? We got some messed up, technology there. There's a lot of conversation on the sidebar right now. Sucks naturally. The evidence that Higgins wasn't actually butt dialing on its own makes me annoyed the video wasn't preserved properly. I mean, that's true. That's such an important part of the case. Higgins said that he didn't make any phone calls that night. He went to the Canton Police Department just to move his car, administrative work, depending on which testimony you go by. And then he didn't make any phone calls. And that's what he testified to in the federal grand jury, apparently. That's what Jackson said. Not that I saw the transcript, but that's what Jackson just said. It seemed like that was disputed. So he testified in the federal grand jury that he didn't make any phone calls that night. And the only phone call that just happened to register was a butt dial. And now you got video of him making a phone call that night at 1:30 in the morning. That's extremely exculpatory. And we're just finding the stuff out now. It's mind-boggling. It's mind-boggling. And let me tell you, when Higgins gets on the stand, if there is a second trial after this motion to dismiss is most likely denied, he gets on the stand. I mean, he's going to be made to look like an absolute fool and liar. Because if they've got him on record to the federal grand jury saying that he did not make any phone calls that night at all, and the only one, and then you got him in the previous trial saying no phone calls at all, just a butt dial or a butt answer, whatever you want to, whatever happened. And now they've got a video of him saying, "Oh yeah, is that you not making a phone call there when you're on the phone, walking around outside? Did you just forget about that? Who are you calling?" Unbelievable. And then he went and destroyed that phone, right? SIM card. You got Jonah K. Higgins will be hoping for that motion to dismiss. Do you mean that he's going to hope for that motion to dismiss to be granted? Leslie, the destroyed phones are so damning. Yeah, I mean, that's one of those things about this case. Everyone's getting rid of their phones, changing carriers, destroying their phones. Just another one of the coincidences of this case. And I say coincidences because if you haven't seen my video about the coincidences, you should definitely go check that out. Yeah, there's so many things about this case. I mean, look, I don't think this is likely, but Hank Brennan could get to a point where like he just keeps digging and finding more and more information, and he can just say, guys, this is just even beyond for what I can handle, and I don't feel right bringing this case. So we'll see. I really wonder, though, again, what his biomechanical engineer is going to testify to. Here's a question from CS. Could Lally or Brennan be sanctioned for not turning over the newly found videos if they don't dismiss? So there are other sanctions available, yes. A monetary sanction is also possible. Okay, let's see what's going on there.
All right, so I will hear you Mr. Brennan, on your motion for reciprocal discovery.
Your Honor, we're expecting to file a certificate of compliance this morning. We've provided voluminous discovery to the defense, and it is now incumbent upon the defense to reciprocate pursuant to the rules. I filed a motion to reciprocate. Also, there is a specific motion regarding expert witnesses relative to so-called ARCA experts. Those requests are consistent with information that we routinely provide pursuant to Rule 14, and we are asking that the defense comply if they expect to call these witnesses at trial.
And you've asked for, you have specific requests for the discovery, right?
I do.
All right. Mr. Jackson,
Thank you, Your Honor. I appreciate the opportunity to be heard on that. I appreciate Mr. Brennan's indication that he intends to file the certificate of compliance today. We know what our obligations are under Rule 14, and we intend to comply.
okay. All right, so the motion is allowed. And Mr. Jackson, you had a scheduling concern?
I do. Concerning we received notice of discovery number 58 last night. It probably, I'm guessing it contains between a dozen, maybe 15 categories of new information that we're getting within that notice of discovery. They're substantial, including multiple experts, some individuals that we've never seen anything from. There, I believe that upon review and analysis, some or all of that will be relevant to our motion to dismiss, which I think is going to be pretty full-throated. The court indicated that it wanted us to file our motion to dismiss, I think, by the 11th, which is in 6 days from now. I don't think that's a reasonable possibility. We simply cannot get it done that quickly. I would ask the court, urge the court to allow us until sometime the beginning of March. We've got several dates on calendar. I don't have them committed to memory, but we'll be back at the beginning of March. That motion to dismiss, I think, if we have the time to do it and get it filed by the beginning of March, it's not going to take an enormous amount of court time. The time that's going to be taken is our preparation of the motion. But actually arguing it and ultimately the court either taking it under advisement or deciding on it, I don't think is going to be that burdensome.
So basically, remember what happened at last hearing. Last hearing, the Judge Canonia was saying, okay, when can you file this motion to dismiss? We got to get things moving because we have an April 1st trial date. By the way, just personally, I don't mind if this trial gets moved to May 1st, just personally. Okay. I have a lot going on in April, but that's just my own personal thing. But anyway, so she was saying, okay, you got to get all this stuff done. And Jackson said, well, we can't tell you when we can file our motion to dismiss until we see all of the discovery. What happens if they provide some new discovery and then all of a sudden, oh, wow, there's another issue for Brady that we have to bring up because we never saw this evidence either before either. So Alan Jackson said, he said, look, I can't tell you for sure when we can file our motion to dismiss until I see all of the discovery. And what Brennan just said is that they're going to file this certificate of completion of discovery today, which he was supposed to do this yesterday, but okay, today he's going to file this certificate. Well, and Brennan said, I already turned over everything to the defense. So now the question is, okay, can you file this motion within 6 days? And now Alan Jackson is saying, quite honestly, we can't. Now, you remember the last hearing, Hank Brennan said, the judge asked him, what more do you have to provide to the defense? I mean, what are they waiting on? And he just said, well, a neurologist report and a inconsequential testimony from a witness or something, some report from a witness, nothing too exciting. So there's no reason why they should not be able to file this motion to dismiss within 6 days from today, right? But now Alan Jackson is saying, well, Your Honor, we just got a whole bunch of stuff, a lot more stuff than what Brennan said he was going to give us. And we have all this new stuff now that we have to comb through and see whether there's more Brady material that was not turned over. And therefore, we can't possibly, like if we knew already today what we're dealing with, okay, we can get working on the motion. 6 days later, we'll file that motion. But now we have to start combing through all this new discovery that he just dumped on us. It wasn't just a neurologist report and one other thing. It seems like it was significant, a number of different categories of information. So we need more time to file that motion to dismiss. So that's quite simple. We need to look through all this discovery and have more time. So now he's suggesting perhaps in March that he can file that motion to dismiss by March.
Although it's going to be a very, very full-throated motion.
All right, so you first raised the issue, I believe, in a footnote in one of your other motions that was filed, I don't know, January 21st or earlier, that this motion to dismiss is coming. You had a motion to dismiss it the last trial, the same thing, forecasted, and then it's coming, it's coming. I need that motion in order to get it heard before then. Let me hear what the Commonwealth has to say. What's the extent of the information that you provided today or yesterday?
In the most recent discovery,
Yes,
it was voluminous.
okay,
We provided a number of expert witnesses, entire files of expert witnesses. We've been providing discovery in an ongoing manner rather than wait until the end. When I've retained an expert, we've notified the defense. When we have reports, we've notified the defense and provided them almost immediately. But there is quite a bit of information that we put together regarding expert reports and data information, accident reconstruction, phone investigations. So we sent it by link because it was extraordinarily large.
okay. Does the defense anticipate evidentiary motions in this case? At time that maybe I can flip these. Do you anticipate evidentiary motions?
Can I just- I don't anticipate evidentiary motions from our end. Obviously, if that changes, I'll let the court and counsel know immediately, but I don't think so.
How about the Commonwealth?
They are none expected.
Mr. Jackson, I'll give you until February 20th to file that motion to dismiss. And we'll hear it. If there are no evidentiary. Commonwealth, I'd like you to comply with your response if you could by the 27th, 28th. Oh, wait, this is March. I'm sorry. No, February 20th. Yes, if you could have it by the 27th, please. And then we will have a hearing on it on March 4th. If there are any evidentiary motions, they must be filed by February 11th. And I want you to talk about whether we have a voir dire of the defendant's proposed witnesses, because we'll have to do both at the same time.
Your Honor,
Right.
is it possible, I'm just looking at the calendar for the first time as the court's going through its calendar. Is it possible that I could urge the court to allow us the 24th to file the motion to dismiss? That gives us a weekend. That is incredibly meaningful for us. I don't want to hamstring the Commonwealth if they need until the 3rd to give them a weekend.
No,
Possible?
but also I need weekends.
Right.
So it's not possible. So I'm giving you from February 11th to February 20th. I'll give you to the 21st.
Okay, 21st. Thank you, Your Honor.
Commonwealth, I'll give you to the 28th. Okay.
Thank you.
All right.
So Judge, are we taking off 218?
We're going to take 2-8. Let's keep it on now.
Okay.
If you work out if you believe that it would be helpful after talking to do a voir dire of those witnesses, we've got the 18th free.
The 18th of
February. You were supposed to be here anyway on your motion to dismiss.
Okay, I'll discuss it with Mr. Brennan.
All right. Thank you all.
Your Honor, may I?
Yes, I'm sorry.
A few things, housekeeping matters. One, I'd like to set a date for reciprocal discovery. There has been no
Yes.
date sent. I'd like to.
All right, so you were filing your notice of compliance today. Do you have it now to file?
I do. Can I just show
Okay.
it to the defense?
Sure.
Oh, it's an extra copy? Okay. Awesome, thank you. May I hand this in, Your Honor?
Thank you.
Thank you, sir.
Here's from
All
D-Rat.
right,
I hope Karen sues the crap out of these prosecutors
so all
and
reciprocal
cops after
discovery
she finally is exonerated.
be provided by March 6th. All right, thank you all.
One last.
Yes, I'm sorry.
Could we come sidebar for this?
Sure.
And then we got another comment from MRad. It's hard to determine if the judge is A, way too deferential to the prosecutor, B, corrupt, or C, astonishingly stupid. This case has to be dismissed if the court is to have any integrity at all. And I can't say that a lot of people don't agree with you. There's so many issues with this case at this point that we keep seeing and keep discovering over and over and over. And again, I think, like I've said this before, but I imagine that there's reasons beyond what a normal prosecutor wants to get a conviction and justice for, why they're continuing with this case. I think there's some political reasons and some other reasons why they're trying so hard to get this conviction. And it could be that in a normal situation when things weren't live streamed and all the public outrage and all the publicity about a case like this case would have gone on, and it could be very quietly this could have gone away. But at this point, it could be they're already so sunken in that they're going to need a verdict. Question from Starless Sky. Is it normal for a judge to give a deadline to file a motion to dismiss? Yes. Almost in every single case. You always have dispositive motion cutoffs. So you got to file your motion to dismiss by a certain time. And there's been times where the attorneys won't do that and they'll file it after. And then, of course, one of the arguments back is going to be, Your Honor, it's not proper procedurally. And then some judges will allow it, some judges won't. You can be sure that Judge Cannoni will not allow it. So that motion to dismiss has to be filed. And weekends are extremely important. I mean, I don't know how many people from Jackson's office is working on this, or Yanetti's office, or Alessi's office at this point. I don't know if they have any ghostwriters or people doing research. But this is, a motion to dismiss to only have, let's see, it's February 6th now. Now they got all the discovery to file a motion to dismiss by February 20th. So number one, to go through all the discovery and be able to file this motion. Motions to dismiss are voluminous. I mean, they're very long, and usually, and you have to really cite a really solid law, and it can really take a lot of time. And if you're not concentrating on any other case, so like even if you're just concentrating on this case, to be able to put all that stuff together to file a motion to dismiss is not simple. So I'm assuming that they're having people already working on this already for the past little bit of time.
Mr. Brennan, anything else?
Thank you very much, Your Honor.
Mr. Jackson, anything?
No, Your Honor, thank you.
All right, thank you all.
All right. Well, that's going to be it. Well, that's it for that motion. Very interesting. Definitely very interesting. I'm just so happy to be home. I'm happy to be back. I was traveling for more than a week. And we'll most likely, like we usually do, we'll put out a recap of what happened. I think that we may have missed some in the beginning. I don't know what was going on there, but when the feed cut in, you just saw Jackson by the stand, by the podium. So what happened before that exactly? And why wasn't Law and Crime Network streaming it? I don't know what happened there. But if there's any questions, you can kind of put it in the chat right now. We'll take care of it. In the meantime, I know there's been a lot of speculation about the Massachusetts Supreme Court, when that decision is going to come out. And that's an important decision, because if they decide, hey, sorry, there's double jeopardy here, no case at all, no trial, everybody go home. If they don't decide that, then the case goes on. So everyone's kind of waiting for it. And there's been a number of opinions recently issued that have to do with declaring a mistrial, and the same exact issues that were argued in Karen Reed's appeal. So, we're usually a lot. I mean, sometimes there's some speculation that sometimes the judges will all talk about the same type of issues with all the cases that come in front of them, right? The Supreme Court, there's always different cases that are being argued. Some have nothing to do with each other. But sometimes what they'll do is they'll batch all the cases that have to do with the specific same discrete legal issues, and they'll just knock them all out. And that's a little bit easier because you're just researching the same type of law about, these 5 different cases, and then you put all the opinions out. So we'll see And either way, I think that the opinion is going to have to come out relatively soon. I think that opinion is coming out soon anyway, because I think it was heard. What time was it heard again? I even forgot already. Was it October or November? But if you go according to how much time they try to get these opinions out, we're coming up on that time. So I assume that we're going to be getting an opinion on that pretty soon, and then I'll explain to you most likely why I was right, even though. How petty is it for me to just make a video about why I was right? But don't put that past me. I may just do that. So we'll see. I do have my opinions about the appeal, as if you've been following my channel at all. Back then, we did a lot of extensive breakdown of the law that has to do with double jeopardy. It's an extremely interesting issue of the law, double jeopardy, especially as it relates to mistrial specifically. Everybody understands when there's an acquittal, then there's obviously double jeopardy. But what other times can certain things rise to a double jeopardy? And one of them is if a mistrial was declared inappropriately. And we went through all the law on it. It's very interesting area of law, but we went through the law, we broke it down, and I think that there's some confusion even amongst lawyers about how to analyze this. And we'll see if the Supreme Court themselves analyzes it correctly. I'll let you know. Don't worry, I'll let you know. So that's what we have there. Okay, any questions here? Okay, Jesse Pink, do you think there are any highly appealable issues? Going through the entire case, I have to think about the entire case, about which rulings were made, and what they're allowed to, testify about. I remember Dr. Marie Russell during the first trial was only allowed to testify about that it was consistent with a dog attack and not consistent, and not that it's not consistent with an a motor vehicle strike. So maybe that's an issue that can be appealed. I have to think about, go over all the rulings that she made and think about whether, how egregious they may be, or whether it's what the standard is, also abuse of discretion. So there has to be some more research done specifically about what rulings she actually made, and if those rulings were, what standard is abuse of discretion. Generally speaking, a lot of these issues are abuse of discretion, which is a very high standard. So I'd have to go through it. Here's a question. Jesse Pink, do the appeal courts actually have to read the entire transcripts? They actually are supposed to. So there's definitely supposed to read the transcripts, or at least definitely the transcripts that you're arguing about. If there's a specific ruling that you're talking about, but if there's a lot of issues if there's no issues raised about jury selection, they don't have to read through all those. But any issue that they're arguing about, they have to read it. Sure. Okay, this is just a question about the actual appeal. Math agrees. Well, they would likely only find double jeopardy on counts 1 and 3, but not 2. So the answer to that is actually, if there is double jeopardy, which is one of the issues that I first talked about when I was talking about this idea of double jeopardy. If there is double jeopardy in this case, then it would be for all counts. It should be for all counts. And that was one of my issues, that they're only talking about it for counts 1 and 3 and not 2. No, if there's double jeopardy attaches to everything. So there would not be any retrial. Here's a question. Nana King, is it normal for the Supreme Court to take this long? And why wouldn't they wait for the answer before going to trial again? They should wait for the answer. They should wait before going to trial again. But the trial court is not limited. Unless there's a specific motion that's filed to stay the proceedings until the Supreme Court rules, the trial court's going to ignore any appeals. And then they're going to just forge on. That's what the trial courts are supposed to do, unless there's a specific order to stay. That's number one. And is it normal Supreme Court to take this long? Yes. Supreme Courts take time. Everything takes time, especially the appellate courts. Everything just takes forever. I have a case right now that's going on for over 7 years because we're bouncing around the appeals. Court of Appeals, we're in the Supreme Court, back to the Court of Appeals, try the case again. I mean, we're just bouncing around all the time. So these things can take a lot of time. Let's see what else we got here. Okay, this is something I'm also going to talk about on my recap, because I know that this was a little confusion there. What's the deal with preservation order in 2022? Okay, so in 2022, it was in the district court, Stoughton District Court. And that's when Yannetti filed his preservation request, his motion to preserve all the evidence. What Judge Cannoni was saying is that when the case moved to her, there was no, or what she was saying was there any motion filed in her court, not just the district court? That's what she wants to know. And Yannetti first said that it was attached as an exhibit, meaning the motions that he made in district court were attached as an exhibit, and then sent to Cannoni's court, Judge Cannoni's court. But then he also said that he thinks that there was a renewed motion, and I think I saw that also, by the way. I think I saw that he did renew that motion in front of Judge Cannoni to preserve all the evidence. Now, again, it doesn't really matter so much because the Commonwealth has a duty to preserve it regardless, not irregardless, regardless. So they have to preserve it anyway. And the issue really, and again, something that Brennan was talking about is that there's, what exactly is the motion in front of the court? And also, I'm going to explain this a little bit more in the recap. This isn't, what he was arguing, this isn't a Rule 14 violation motion. This isn't a motion for sanctions pursuant to Rule 14 violation. Okay, this is just in terms of them trying to get an expert there, and it was not fair, and they were led, a wrong way. So what you call your motion and what you're arguing your motion for in front of the court matters. And that's what Brennan was saying, that this isn't a Rule 14 violation motion. This is just a motion because you want to get reimbursed for costs. So it doesn't, he was trying to, split some hairs that way. But that's what, in terms of the preservation order, what they were talking about. Let me see. We go. Marzipin Rose, is the defense request for preserving evidence valid as it was not done in this court? Of course it's valid. Yeah, it's definitely valid. The Commonwealth has to preserve it. It was filed in a court. It was signed. So they have to preserve it, even though you move courts. But anyway, he said that he renewed it anyway. And again, it doesn't matter. It doesn't matter because the Commonwealth has to preserve it regardless. Any Brady material they were required to preserve. And if you don't preserve it, then that could be basis for dismissal or another sanction. And we've had cases like that also, where they want to, you have the other side, and the other side is conveniently trying to hide information from you, and you find that out, there can be some severe sanctions against that other side. Wait, Bev denied the order in October 2022. Is that you're talking about the order to preserve? I wasn't sure about that. Okay. All right. Well, I'm going to be doing another recap. We're going to do a little bit more research, and we're going to be seeing, the different things that they were talking about, and break it down for all you. So that's going to be it for now. Thank you all for joining. Appreciated it. And we'll see you at the next hearing. And you guys have to just update your calendars because February 18th is no longer the motion to dismiss hearing. So we are going to have to change those dates. So don't forget that. But in the meantime, we're going to be waiting for that motion to dismiss to be filed, which still February 20th, they have to file that one. So you got a couple days for that. And then we have going to have the hearing coming up on March 4th. And also, well, of course, we're all waiting for that Supreme Court decision to come down, which may come down any day. Who knows? It may come down any day. And when it does come down, we will break that down for you. So don't worry about that. All right. Thank you all for joining. If you haven't by this point, all of you who are watching, definitely please like and subscribe. Costs nothing. And if you really want to support the channel, you can join the Brother Counsel sidebar, which is only $2.99 a month. It's like a joke, and a very easy, cheap way to support the channel. And you also get some extra content. We have a lot of fun with the Q&As in the members only. So definitely join that. All right. Well, thanks a lot, all of you again, and we will see you, like always, next time.